Well, welcome everyone. Thank you so much for being here today. My name is Carrie Wilson and I'm the Dean of Admissions at Maine Law. Each year at Maine Law, we like to highlight the impact our faculty and students are having in their community. And in this case, it's a national impact. So last week, Maine Law's Refugee and Human Rights Clinic, along with a coalition of legal advocacy groups, released a report shining a light on the work of the Boston Asylum Office. Professor Welch, the founding director of Maine Law's Refugee and Human Rights Clinic, and her extraordinary students were at the heart of this work. So without further ado, I turn it over to Professor Welch and her students.
Fantastic. Thank you so much, Carrie. And thank you, Carrie Bailey and Carrie Weiler, for organizing this event. It's wonderful to be here with my fellow co-panelists. My name is Anna Welch, and as Carrie mentioned, I'm the founding director of Maine Law's Refugee and Human Rights Clinic. I'm going to allow my students to introduce themselves.
Hi, everyone. My name is Emily Gorovin, and I'm a third-year student and a student attorney in RHRC.
Hi, everyone. My name is Cameron Rivera, and I'm also a third-year student and student attorney in the RHRC.
Hello, my name is Jamie Knorr. I'm a 2L and also a student attorney at the RHRC.
Hi, my name is Aisha Simon. I'm also a second-year student and student attorney in RHRC.
Hi, all. I'm Grady Hogan, a 3L and student attorney at the RHRC.
All right, thank you, everyone. So the plan for today is to provide some background on Maine Law's clinics, including the Refugee and Human Rights Clinic. But the majority of the time today, we want to spend talking about the report. And I would love my fabulous students, my co-panelists here, to sort of walk you through both their experiences in the clinic and also their experience in working on this recent report. So first, the Refugee and Human Rights Clinic is one of several clinical programs at the law school, including our fantastic Youth Justice Clinic, our Prisoner Assistance Clinic, and the General Practice Clinic, as well as our Protection from Abuse project. All of our clinics, we have some differences certainly, but all of our clinics share two core goals. First is we want to provide critical opportunities for students to learn how to be lawyers. One alum recently referred to it as lawyering on training wheels, where students conduct their work under the close supervision and support of professors here in the clinic. So students in the clinic gain core lawyering skills, regardless of which area of law they ultimately intend to practice. And our second goal, beyond educating our students, is for students to work to help to bridge the access to justice gap by working on real cases and on real advocacy projects on behalf of some of the most vulnerable populations. So immigrants, children, domestic violence survivors, among so many others. And it's really wonderful for us to see the multiplier effect created by our clinical programs. So our students are truly the next generation of legal advocates. And many of them go on to work full-time advocating for individual and systemic change, whether working for nonprofits or working within the government or in the private sector. So students in the Refugee and Human Rights Clinic work on a range of cases and projects. They represent immigrants on humanitarian immigration matters, including, for example, asylum cases or cases involving immigrant youth. They also engage in a number of advocacy projects, including impact litigation before our federal courts, including the First Circuit, immigrant detention, know your rights trainings. They prepare a lot of education materials, among a number of projects that help fill an acute community need. So I'm more than happy to answer questions following this webinar about the clinic, about my clinic, or about our clinical programs more generally. But now I want to turn our focus to the report. So before I turn it over to my students to discuss the report and their experiences in the clinic, I'd like to provide a bit of context for our work on the report. When I launched the clinic 10 years ago, we handled primarily asylum cases, and then our cases were before the Newark Asylum Office in New Jersey. This was the office that had jurisdiction over Maine cases, and they would travel up from New Jersey to Maine for weeks at a time to adjudicate the cases that were pending here in Maine. And uniformly, the asylum officers expressed gratitude for my students' hard work on the cases, often praising them for their thorough, well-organized, and well-prepared cases. You know, our students in the clinic work dozens of hours, hundreds of hours preparing the strongest cases possible for their clients, conducting numerous client interviews to develop the facts of the case, working with experts, mental health experts, doctors, country condition experts to help corroborate the client's story. They draft legal arguments, just so much work going into the preparation of an asylum case. And for years, nearly all of our clients were granted asylum by the Asylum Office. But then the Boston Asylum Office was open, and we, along with our colleagues throughout the region who practiced before the Boston Asylum Office, noticed an incredible decline in approvals. And nothing had changed on our end. Our clients are still fleeing countries where there's well-documented human rights abuses, and we are still preparing the strongest cases possible. And so we undertook this project in collaboration with our partners, the ACLU of Maine and the Immigrant Legal Advocacy Project, engaging in multiple modes of advocacy to try to answer the question of why. Why are we seeing this dramatic decrease in approvals? And so while the report focuses on the Boston Asylum Office, unfortunately, the findings in the report we think are relevant, systematically relevant across all of the asylum offices around the country, which raises serious due process concerns for those fleeing persecution and who under our laws should be afforded protection. So I'm now going to turn it over to my students who worked on this project over multiple semesters, but they alone are not the ones who worked on this. We had multiple semesters of students, and not everyone can be here because many have graduated and gone on to practice, but they did the majority of the work on the report itself. And so I will turn it over to Emily to walk you through it.
Thank you, Anna, for providing that helpful background information. As Anna said, the report concerns practices at the Boston Asylum Office. And asylum seekers at asylum offices apply what's called affirmatively, as you'll see here on the webinar. I want to begin with a brief overview of that process to provide some context for this adjudicatory process. So an asylum seeker who is in the United States and who is not in deportation proceedings files affirmatively with United States Citizenship and Immigration Services. And I'll call that office USCIS throughout this presentation. Once an asylum seeker files their application with USCIS, the asylum seeker is interviewed by an asylum officer. The asylum officer has the power to approve the case if they find that the applicant is a bona fide refugee. And if they don't approve the case, they often send the case to immigration court, where the applicant will have to wait several years and then present their case to a judge. So with that background in mind, I wanted to expand a bit about the explanation and the impetus behind the report that Anna mentioned. As Anna said, in 2016, after the opening of the Boston Asylum Office, attorneys saw a drastic decrease in asylum approvals. And as you can see from the figure on this slide, the Boston Asylum Office, which is illustrated by the blue line, grants asylum cases far less than other offices nationally. The national average is illustrated by that light brown line. The average grant rate for the Boston office from 2015 to the end of 2020 was only 15%, whereas nationally that rate was nearly 30%. And so seeking to answer that question, why does the Boston office approve so few cases? The RHRC, the ACLU of Maine, and the Immigrant Legal Advocacy Project engaged in a multi-year, multi-modal advocacy project. The project includes an ongoing lawsuit in federal court seeking to compel government production of documents that we requested in a Freedom of Information Act request. And it also involved a comprehensive investigation into practices and policies at the office, which Cameron will discuss in a few minutes. And as Anna said, the results of this investigation culminated in an exposé, which is our report, that highlights systemic problems which affect Maine asylum seekers and asylum applicants countrywide. So now I'll turn it over to Cameron to talk in more detail about the methodologies that I mentioned.
Thanks, Emily. So like Emily mentioned, this has been a multi-year project. In fact, I started working on this project as early as my first year when I was volunteering in the RHRC. Emily started working on this project during her summer internship that she did in the RHRC through a Maple Fellowship. And then we added Jamie, who had worked previously for ACLU of Maine working on this project, and Aisha, who had been working on this project through ILAP as well, and then Grady, who is currently in the border, and so he'll pop in and out, I'm sure. But really, initially we had filed this FOIA with USCIS in 2019, like Emily mentioned, and we had asked for all the records that involved the Boston Asylum Office and the Newark Asylum Office's policies, procedures, objectives, and decisions for any asylum application that dated back to January of 2010. But as Emily noted, USCIS did not respond to our request and refused to expedite our request despite the urgent need for this information. So in collaboration with the ACLU of Maine, RHRC students filed the lawsuit in federal district court in hopes to compel USCIS to produce that information to us. The RHRC students were really involved with the litigation. We had conducted legal research on the best arguments to make. We had strategized those arguments, and we had drafted, reviewed, and edited the court filings. And that's one of the unique things about the RHRC, is that as student attorneys, we are equal players at the table, and all of our collaborators from day one have treated us like we're attorneys. We're at the table making those decisions, talking through them, editing things, and they really value what the RHRC students are bringing to those meetings. And this also gives us a lot of great opportunity to learn how to interact with community members and strategize for these bigger issues that are multi-organizational. So eventually USCIS started producing some documents. They released over 6,000 pages, but a vast majority of these were highly redacted, and we're still litigating the degree of those redactions in federal court. And they also produced a large database for both the Asylum Office, or the Boston Asylum Office, and the Newark Asylum Office. And so in addition to reviewing these documents and analyzing the data, the RHRC began interviewing asylum seekers, immigration attorneys, former asylum officers, and former supervisory asylum officers. Our student attorneys conducted all of these interviews. We drafted the questions, we corresponded with the interviewees, and then analyzed all the qualitative data that we obtained from the interviews. And then once we took a step back from all this information, we saw the big picture, that the Boston Asylum Office is really the perfect storm of having a culture to refer certain asylum seekers while exhibiting some major procedural failings. So the report, which we'll walk through in just a minute, was drafted almost entirely by RHRC students. We had a lot of input and collaboration with ILAP and the ACLU of Maine, but by and large, RHRC students have written the report that we're about to present to you.
So I'll shift now to a discussion about the summary of the findings that emerged from this report. Overall, our overarching finding was that the Boston Asylum Office is dominated by a culture of suspicion and distrust toward asylum seekers, which is further exacerbated by internal pressures placed on asylum officers. Our findings demonstrate that the Boston Asylum Office is failing asylum seekers in violation of our international obligations and domestic law. This causes uncertainty and compounds trauma for asylum seekers and their families. These violations also result in what we call legal limbo, which we'll talk about more in just a moment.
So through the report, we came up with a number of findings, and Aisha and I are going to go back and forth and describing those to each of you. The first of which we got through our interviews with former asylum officers and supervisors, is we learned that the Boston Asylum Office's high referral rates are driven in large part by the outside role the supervisory asylum officers play in the adjudication of asylum claims. So every asylum case is reviewed by supervisory asylum officers. When the Boston Asylum Office first opened, a large number of supervisory asylum officers from the Newark Asylum Office moved to the new office, but former asylum officers shared that many of those supervisors had a predisposition to refer cases. And so in turn, this had set the tone and culture of the office from the beginning. And we'll discuss in just a moment that asylum officers have a large list of duties to complete, and they're given tight deadlines to complete those. And so to avoid having to repeat a lot of the work, asylum officers tend to fall in line with what the supervisory asylum officer would like the outcome to be in any given case. For the Boston Asylum Office, where the culture is to refer most cases, this leads to a higher tendency to refer than other offices nationwide. And then the second piece to the supervisory big impact on the outcome is that supervisors have a lot of control over the performance review of asylum officers. And so asylum officers are rewarded or given performance points when they are processing cases quickly and coming to cases that align with their supervisor's outcome on how they think the case should turn out. And conversely, they're penalized when they are having to spend more time on cases because they've disagreed with the supervisor or because the supervisor wanted an outcome that the asylum officer did not reach in a particular case. And as one former asylum officer put it, deciding a case contrary to the supervisor is, quote, like swimming upstream, end quote.
We also learned that there's a large degree of bias that occurs in the Boston Asylum Office. As Cameron mentioned, those hired in the Boston office from Newark were often those who were inclined to deny or refer cases, which set the tone for the culture in the office. As one former asylum officer put it, humans are not neutral. We are biased. We are discriminatory. People have a very hard time being a neutral adjudicator. There are very few people who can naturally put their biases aside. So for example, the data shows that Central African countries tend to be granted asylum at much lower rates. If you look at the Democratic Republic of Congo, which is the second country listed on this table, only 4% of cases are granted at the Boston Asylum Office. But the US State Department has explicitly recognized that significant human rights abuses occur within that country. If you compare this number with the Newark Asylum Office, which is in yellow on the right in that table, you'll see that the number is even more striking. The Newark Asylum Office approved 33% of DRC cases in the same period. The data also shows that English speakers fare far better at the Boston Asylum Office than non-English speakers. In fact, English-speaking asylum seekers are nearly twice as likely to be granted asylum and are only referred to immigration court 60% of the time, while non-English speakers are referred to immigration court 80% of the time. This bias might be explained in a couple of ways. First, asylum officers might be exhibiting implicit bias for traits that are commonly associated with English speakers, such as higher education levels or socioeconomic status. Or it could be explained by the fact that asylum officers are already so strapped for time that needing to use an interpreter results in hearing less facts of the asylum seeker's story. This, in turn, limits the amount of facts that the asylum officer can rely on to grant asylum. Regardless of the reasons, it's important that our recommendations address both of these possible underlying issues.
So the third finding from the report was that asylum officers have large caseloads with a lot of tasks to do for each caseload, and they're not given a lot of time to do it, which results in a lot of pressures. And this pressure causes asylum officers to then cut corners when they're adjudicating cases. So if you think of due process as having a fair opportunity to present their case, it's crucial that asylum officers put in the groundwork to consider all of the facets of the asylum seeker's story. It takes time to ensure that asylum seekers are afforded due process, and that time and that process is required by our international obligations and domestic laws. And so just to name a few of the tasks that asylum officers need to complete, they need to conduct thorough country conditions research, they need to review large asylum filings, think about how to conduct the interview, actually conduct the interview, process the asylum seeker's information, and then ultimately write a decision. And we found that asylum officers' workloads are far too large given the time constraints of the office or what they face in the office. And so as a result, asylum officers often cut corners to complete their work and meet the officer's expectations. For example, some asylum officers recycled decisions, or they did surface level investigatory research. This in turn violates the due process rights of asylum seekers.
So as Cameron just outlined, all of the duties that asylum officers have often results in them being overworked. Now, additionally, they're dealing with traumatic stories and they become burnt out and suffer from compassion fatigue. Former asylum officers expressed that the longer they stayed in the role, the more desensitized they became to hearing traumatic stories from asylum seekers. This in turn impacts how asylum officers assess credibility and the strength of an asylum seeker's case. One former asylum officer shared that asylum seeker statements become, quote, so mundane that they lose salience in the process, end quote. This burnout and desensitization also contributes to the high turnover rates of asylum officers.
So finally, really, we learned that asylum officers are usually trying to find the easiest and fastest way to refer cases. And this could be for any of the reasons that we've already mentioned in this report. They could be wanting to refer a case rather than deal with negative supervisory reviews. And as some AOs shared, disagreeing with the supervisory asylum officer would be like swimming upstream. Or an asylum officer might have an implicit bias against the asylum seeker's country of origin and is looking for a reason to refer the case. Or the asylum seeker is burnt out and doesn't have enough time to fully research or hear the entire asylum seeker's story. Regardless of the reason, we learned that some asylum officers and supervisors at the Boston Asylum Office employ what is described as, quote unquote, the rule of threes. Under this unwritten rule, asylum officers are trying to find the lie rather than seek the truth. They bypass the material pieces of the asylum seeker's story and hone in on the peripheral facts that the asylum law does not and should not hinge upon. Under the rule of threes, if the asylum officer finds 3 inconsistencies, then the case is to be referred to immigration court. It doesn't matter if the perceived inconsistency is related to meeting the requirements of asylum. Thus, asylum seekers are expected to remember every minuscule detail of their story every time that they tell it, even though numerous studies show that trauma and time can cause reasonable lapses in memory. Thus, many asylum seekers are being referred simply due to the fact that human memory is not perfect, and especially when that memory is affected by traumatic events.
Thank you, Cameron and Aisha, for sharing those findings. I am now going to talk about the impacts that this adjudicatory process has on the asylum seekers and on the asylum system. So through our research and through my own personal experience as a student attorney, it's clear that the policies and procedures adversely affect asylum seekers. Personally, I've had clients who are immobilized by anxiety regarding the safety of their families. We've had to ask clients to relive their trauma. And our interviews show that this experience is far too common. Specifically, we see these 5 major impacts on the asylum seeker. First, family members remain in danger abroad. Some cases are left unresolved for up to 10 years or more. And during that time, family members of these asylum seekers remain in their countries of nationality. Tragically, we've heard stories of children and spouses dying because of this delayed adjudication. So it's really life or death. Second, I mentioned that cases can remain unresolved for decades, a decade or more. And it's really hard to imagine being separated from your spouse or parent or child for that amount of time. And obviously it causes strains on those family bonds. Third, Aisha referred to something called legal limbo earlier. I have personally met children who grew up in Maine and consider the United States their only home, but who nonetheless face deportation to a country that they don't know at all. This is one example of that legal limbo, and it not only leaves futures uncertain for asylum seekers, but it leaves them without access to some supports like federal student aid. Fourth, this prolonged adjudication compounds trauma. Asylum seekers are forced to relive the worst, most traumatic events of their lives and tell these stories over and over again. And then this trauma, family separation, and general uncertainty often lead to deterioration of mental health. And there are also adverse effects, not just on the asylum seekers, but on the system more broadly. For example, the low grant rate really deters pro bono attorneys from taking on these affirmative cases. And so it leads to negative impacts on obtaining representation. Additionally, even though asylum officers could adjudicate these cases expediently, they don't, and they often send them to the immigration court. And that adds to the backlog of the immigration court, which is nearly 1.6 cases nationally right now.
Foremost, our recommendation is that a thorough investigation should be conducted of the Boston Asylum Office to replace asylum officers and supervisory asylum officers who demonstrate bias or lack of cultural literacy. We'd also like to see a reduction in the outsized role of supervisory asylum officers over the asylum officer decision-making. Increase transparency in asylum office interviews by creating audio recordings of the asylum interviews and making the recordings readily available to applicants and attorneys. We offer several recommendations to improve the quality of work and environment for asylum officers. First, give asylum officers only one case a day. Second, implement rigorous hiring standards that focus on language skills and cultural literacy. And once hired, provide asylum officers with support through mentorships and employee wellness programs. Third, improve trainings to focus on implicit bias and racism, trauma, compassion fatigue, and cultural literacy, and finding the truth rather than the lie.
So like Carrie and Anna both mentioned, we've had a lot of good responses, and we had some national attention for this report since releasing it. This is an article, this slide shows an article from the Portland Press Herald that did a really good job outlining the report and its findings. And they had interviewed some ILAP attorneys as well as me. So I selected my quote to put on there because why not? We also had some attention from the Boston the Boston media as well. So some news stories out of Boston. And then we've also had some responses from the immigration legal community nationwide. Really, advocates around the country expressed strong gratitude for this report. It was the first of its kind to tackle the inner workings of an asylum office. And it was definitely the first of its kind to include the kind of data analysis that we conducted. And so really we've gotten a lot of requests on how did we get this information? How can we do this going forward? How can we figure out what's going on at other asylum offices? Because like Anna said, this issue is probably plaguing multiple offices across the country. And then personally, I've been able to use the findings of this report in my own client meetings. It's been really helpful for clients who have been referred from the Boston Asylum Office to hear about these things that we're finding. And that can shift the blame from themselves, which is really common in asylum seekers, to blame themselves for doing something wrong in the interview versus it actually being the system working against them. So that's been really helpful in my own client work. And since publishing the report, we're hoping that we get some additional attention because literally days after we published it, the Biden administration announced that they were going to be making some changes that will give asylum officers additional authority in asylum cases. And so the timeliness of this report is huge for national impacts, especially for the Boston office. And like I mentioned before, we're hoping that this report might be a new model for how we can assess asylum offices nationwide. And we're hoping that the legal community can start making some efforts to request similar data and conduct similar investigations across the country so we can get a better understanding of the landscape and how asylum offices are operating in different jurisdictions.
Well, thank you all for providing such a thorough overview of the report. Now we're going to talk about the RHRC student experience more broadly. The Boston Asylum Office was an amazing experience, but it's just one example of the wide-ranging advocacy that RHRC engages in. I'm going to discuss how RHRC fills critical needs with policy projects, and then I'll turn it over to my colleagues to discuss the crucial need that RHRC fills through direct representation. So as to policy projects, RHRC leads advocacy condemning immigrant detention in the state of Maine. For example, RHRC was the first legal team in Maine to send attorneys to respond to the immigrant detention crisis in 2015. During Obama's presidency, RHRC sent students to New Mexico and to Texas to help families who were being detained at the border. More recently, since 2016, RHRC has sent dozens of students to Laredo, Texas, to work with asylum seekers detained at our border. There, students have assisted those affected by the Trump administration's Remain in Mexico policy. Grady, who is actually there right now, is soon going to talk about his work there. Our work with detained immigrants also includes work in our own backyard. For example, in 2019, RHRC began a detention outreach project out of Stratford, New Hampshire, which is the detention center that holds most of Maine's immigrants who are picked up by ICE. Then in 2020, during the heart of the pandemic, ICE began bringing people with no connections to Maine to the Cumberland County Jail. Then ICE would quickly deport them, thinking no one would notice because who's paying attention to Maine? However, RHRC quickly collaborated with ILAP and the ACLU to attempt to stop this practice. RHRC conducted dozens of intakes of immigrants and filed a lawsuit in federal court. Personally, RHRC has given me the chance to engage in policy work and has also showed me that there are opportunities for lawyers beyond direct representation. Through this work, I've had the opportunity to build relationships with regional partners like the Immigrant Legal Advocacy Project and the ACLUs of Maine and New Hampshire. I've also made connections with various policy and advocacy organizations in Maine by attending community meetings such as the Asylum Seeker Working Group. Also, Cameron and I co-authored an amicus brief, which is also called a friend of the court brief, to the First Circuit Court of Appeals. So we worked with the ACLU of New Hampshire to advocate for a certain standard of withholding of removal. And we were lucky to receive support from immigration professors nationwide. And that's just one of several amicus briefs that students have filed with the First Circuit. So to give you a sense of the breadth of RHRC's advocacy, we're going to hear from each student attorney on this panel. Aisha is going to talk about direct representation generally, and then Cameron and Jamie are going to talk about a couple different types of direct representation. Cameron, who's our resident special immigrant juvenile status expert, will discuss his experience, and then Jamie will conclude this portion by talking about humanitarian parole. I do want to note, though, that these are just two examples of the representation that RHRC undertakes. But they are very interesting examples to share.
Thanks, Emily. I'll get started. A big thanks to my fellow panelists here who let me off the hook on this presentation because I am in Laredo, Texas for the week. As Emily mentioned, since 2016, RHRC students have been coming down to Laredo. We have a relationship with a very big law firm called Jones Day, which does a lot of things, but one thing that they do is they have a border project where they have a few offices along the southern border and do a variety of different immigration law related work to assist the folks who are trying to enter the United States. Depending on the federal policies at the moment, their work I think varies a lot. What we've been doing this week has been sort of in three parts. The first is we've been going to ICE detention centers and talking to folks who are subject to expedited removal and helping them understand the legal process that they're in, what they need to communicate to the asylum officer. For folks who are subject to expedited removal, and if they're seeking asylum or seeking withholding of removal or other humanitarian relief, they generally don't get the full immigration court proceedings that another individual would. Instead, they have a phone call with an asylum officer, the same asylum officers that we've been talking about today. And during that call, the officer determines whether or not this person has a credible fear, a reasonable possibility of establishing an asylum claim if they were given the opportunity. So if yes, if the asylum seeker is credible and has facts within their story that the asylum officer believes might entitle them to asylum, then they are generally released from detention and allowed to pursue asylum claims through the regular immigration court process. If no, they basically get a cursory immigration judge review and then they're deported. So when we visit the detention centers, the goal is to help people understand where they are in the process. Ideally, we speak to them before their credible fear interview and explain what the legal standard that the asylum officer is looking for, and then talk to them one-on-one about their experience and what are the important aspects of their story to make sure to highlight with the asylum officer. Another thing we've been doing is going to the Catholic Charities shelter here in Laredo. When if folks pass their credible fear interview and they are released, they can be subject to detention for the duration of their immigration court proceedings. Right now, a lot of people are being released to be able to pursue their asylum claims and do their immigration court process while not in detention. they get dropped off at this shelter. The first day we were pulling up on Monday, an ICE bus was pulling up as well and dropped off, 50 or so folks who had just been released from ICE detention. They're at this shelter typically for just a couple of days. Most people, 99%, according to the supervisor down here, have relatives or friends or places that they're planning on going that are expecting them. And so they come to the shelter to charge their phone and make plans to get buses or to get planes to various points throughout the United States. The sessions that we do at the shelter are, again, sort of high level, know your rights info sessions, but then speaking with people and really trying to help them understand what documents they have. So they're given documents in English. Of course, most people don't speak English, and they have very important information contained on these documents, primarily when they need to check in with ICE and when they need to report for their immigration court proceedings if they've been scheduled them. Some people don't have their immigration court proceedings scheduled yet. And other folks in this group at the shelter have just been released by CBP as opposed to ICE. I think my biggest takeaway from being here this week is just how it seems like a crapshoot, which legal route people are subject to. There's a lot of discretion in the immigration laws at the border as to whether people are subject to expedited removal or MPP, or can just be released by CBP. And as the interpreter I've been working with down here has said, where there is discretion, there is discrimination, which is not an original sentiment, but it's illuminating. And then a third thing that we've been doing this week is going to the immigration courts at the border and observing MPP proceedings. MPP stands for the Migrant Protection Protocol, also known as Remain in Mexico, which was initially a Trump era procedure in which people who are seeking asylum have to wait in Mexico for the duration of their immigration court proceedings, and then they cross into the United States on the day of their immigration court hearing and see the judge in a tent court, and then go back to Mexico waiting for their next hearing. So they had been on pause in Laredo during the pandemic, but have started up and running again this week. So we've been going to those the master calendar hearings, sort of the first court dates for people who are subject to this MPP protocol. Rather than drone on any longer, I'll pass it over to Aisha, and thanks all for coming.
Great, that was awesome. It's so cool to hear about what you're doing, and I know just a lot of stuff, it sounds like, packed into a week. So thank you for sharing all of that and explaining it so well. I'm going to talk a little bit about the client work that we do and the skills that you get from working with clients in the clinic, and how those are transferable to really any part of the legal field or career that you choose after law school. So the first thing is that in our client work, the clinic really addresses or focuses on what's called client-centered lawyering. It's a method of thinking about the attorney-client relationship. So it's focused on collaboration. The goal of the attorney is first to understand the client's motivations and objectives, and then to provide the client with objective counsel on their options. So sometimes people might expect that a lawyer's coming in and they're going to say, I have a superior knowledge of the law based on what I know. This is what we should do, and these are steps 1, 2, 3 to get there. That's actually the exact opposite of a client-centered approach. Instead, the client is the one who's determining the best legal route to pursue. And this is based on counsel from the attorney. So the attorney, as Grady was talking about, works with the client to help them understand the law and the variety of options available. But then ultimately, it's the client who makes the decision. They are the expert on themselves, and they're the ones who will live with the consequences of whatever legal decision is made. Additionally, these skills are relevant in all areas and practices of the law. While many students in RHRC are interested in doing immigration work, not everyone is here for that reason. Some of us have no prior experience in working with immigrants, and many of us might not go into immigration law. Some of us might want to just ensure that we gain core lawyering skills relevant to general practice, which we definitely learn in clinic. Some of these might include interviewing and counseling of clients, especially how do you build rapport? How do you establish a connection with a client? Once you've done that fact investigation and marshaling of evidence, how do we use and obtain evidence that might be both domestic and international in support of our cases? We do a lot of legal advocacy. So how do you write a brief or use oral advocacy in court to assist our clients? We work with witnesses, both lay and expert witnesses, including doctors, mental health experts, and country condition experts. In particular, we communicate legal knowledge in a way that can be understood by the client and they can use to make their own decision. This is a core part of the client-centered lawyering approach. We learn how to organize a case, and attention to detail is a key part of that. So being thorough in our conversations with our clients and in identifying the steps that we need as we progress through a case. We learn how to work with interpreters. So as Grady mentioned, many people crossing the border do not speak English, and many of our clients here in Maine, English is not their first language. So while some of us do have language skills, we also rely heavily on interpreters to communicate effectively and ensure that in our role as an advocate, we're able to be as clear and competent as possible. So working with interpreters is a pretty incredible skill. We learn how to manage our time, how to prioritize, and how to really think critically about what is pressing and how can we approach the different steps of the case in a responsible and effective manner. And then one of the best parts is working with a co-student attorney. So as you have seen, there's an amazing crew here and our supervisors are wonderful. Knowing how and when to ask a question is a really important skill, and being okay to say that you don't understand. There's a wealth of knowledge and expertise here, and that is very transferable to any area of the law or any career that you choose after graduation.
So like Emily said, I'm going to give an example of where I've used a lot of the skill sets that Aisha just went through and had some awesome impact for clients. One of my favorite case types, they're called special immigrant juvenile. And this case type is usually associated with unaccompanied minors. But essentially what it does is it allows for youth who have been abused, abandoned, or neglected by one or both of their parents to apply for permanent residence and can give a pathway to citizenship ultimately. And so there's two steps to this process. The first step happens in state courts, and then the second step happens with the federal government under USCIS. So the first part, you have to go into state courts and you have to get a judge to issue an order that says and makes findings that the child has been abused, abandoned, or neglected by one or both parents. And that's called a predicate order. Once you get a predicate order, you can then apply with USCIS to be granted special immigrant juvenile status and then adjust the status to a long-term permanent resident or a green card holder. So it gives these youth an opportunity to get some sort of permanent status to stay in the United States when it's in their best interest to do so. I think one of the cool things that's unique about Maine law is that we've had some cool legislative changes happen in the RHRC around this area. So under federal law, you can apply to get special immigrant juvenile status up until you're 21, but under state courts, there wasn't jurisdiction to issue these predicate orders past the age of 18. And so RHRC students drafted, lobbied, and passed legislation in collaboration with some other student attorneys from the other clinics that helped fill that age gap. And so now up until the age of 21, you can get these predicate orders now. And so that's really cool. And I know a couple of former students are also the first clinic students to also use that law and get students or clients who are over the age of 18 SIDG status. And so really the reason I like SIDG cases so much is because you can do a lot in a semester. And I've seen in my time here, a couple cases already come through the application to grant stage, and I've got to talk to youth and their guardians about what it means to be a lawful permanent resident and what that means for their future. And I think those are really rewarding conversations to have as a student attorney and see some awesome impact on the community. But really, RHRC is also filling a really acute need for attorneys in Maine in this area. More and more unaccompanied and abandoned minors are finding their way to Maine. And a lot of them end up going without representation. And like I just described, this process is pretty complex because it has multiple steps to it, and you have to go through state court and federal applications. And so the Cumberland Legal Aid Clinic, both working in the family court and then also in the RHRC on the federal side, really are filling a one-stop shop for these clients, which is pretty unique for us. A lot of times these special immigrants are they're given a family court attorney through a pro bono program and then an immigration attorney as well. So there just some extra steps involved when you have multiple attorneys. And so it's been really unique to be able to work with other student attorneys in the other clinics on these. I've been able to establish rapport with the client, like Aisha was talking about, from day one, before they're even done with their family court case and getting that predicate order. I can meet them and talk to them about what the steps are and what the step is after that predicate order. And I also get to collaborate, like Aisha was talking about, working with other student attorneys and cross-disciplinary, so they can review my materials and I can review theirs and really make a cohesive application on both sides. So that's been really rewarding as well. And then I'll hand it over to Jamie to talk about the Humanitarian Parole Project.
Thanks, Cameron. So I'll be discussing the Humanitarian Parole Project, which began this last fall in response to the sudden U.S. withdrawal from Afghanistan and the Taliban's takeover. I'd like to start with first defining humanitarian parole. It's a process which allows those who are unable to obtain a visitor visa to apply to enter the United States based on an urgent humanitarian reason. So, for example, in the past, it's been used to allow individuals to enter the U.S. to seek medical treatment or to visit a sick family member or attend the funeral of a deceased family member. Humanitarian parole is discretionary and it's decided on a case-by-case basis. And historically, it's been used very infrequently, only about 2,000 applications a year. Now, a petitioner, well, this is how it works. A petitioner, and that can be anyone, petitions the United States government on behalf of the beneficiary. In our case, this would be an Afghan, to allow the beneficiary into the United States. Evidence of urgent humanitarian need must be provided along with a sponsor who is an individual or entity who theoretically will sponsor the beneficiary in the United States so that they don't become a public charge. Once in the US, then those beneficiaries, those individuals, need to seek other immigration options, such as applying for asylum. So after the US left Afghanistan in August 2021, thousands of Afghans with ties to the US coalition forces became threatened by the Taliban, who vowed to punish anyone who supported the coalition forces. The US government had not created hardly any mechanisms to protect these people. So attorneys turned to humanitarian parole to use as emergency travel documents, which would allow threatened Afghans to leave the dangerous situations that they faced. Over 24 students at Maine Law, including those of us in the RHRC, but also volunteers from the 2L and 3L classes, all volunteered to help file humanitarian parole applications under the supervision of Professor Welsh, as well as local attorneys. This project has provided us with great opportunities to work with clients in Maine, but also with clients and other individuals trapped in Afghanistan and Pakistan. We were able to be on the front lines of a pressing humanitarian crisis, and it was extremely rewarding.
Well, thank you all for sharing your experiences. It was really amazing to take a look back at all the work that RHRC does. So as everyone can see, there are a lot of opportunities to hone your advocacy skills in RHRC. I want to reiterate, though, that special immigrant juvenile and humanitarian parole are just two types of the cases that we handle in RHRC. Others include asylum, family-based petitions, and naturalization. One of the most rewarding parts of the student attorney experience has been learning how to actually be a lawyer, as Aisha talked about, and also affecting positive change. Obviously, success is super rewarding, and we've had some examples of that in RHRC. For example, one of my clients was reunited with her husband and children after several years. Through letters to senators and other advocacy, we were able to push her family-based petitions through. And of course, the larger systemic advocacy has been extremely rewarding. I'll conclude by saying that, like Aisha said, it's okay not to have immigration law experience coming into this. I know this sounds like a lot of work and perhaps a little overwhelming, but I had no idea what I was doing when I started during the summer of 2022. Clinical faculty have numerous trainings and they provide tons of support. Anna and our other supervisor, Erica, and all of the clinic staff are just incredible resources and mentors. So we encourage you to enroll in the RHRC while you're in law school, and we also encourage you to enroll in other experiential learning opportunities. There are opportunities like externships. For example, I had the opportunity to extern with the ACLU of Maine last fall, where I actually was able to work on the litigation side of the Boston Asylum Office report. And there are lots of opportunities like that here. And there are also other amazing clinical programs which have been discussed a bit, but those include the Youth Justice or Prisoner Assistance projects. So thank you all for your attention to this presentation. We're going to transition to a 10-minute question and answer session before concluding the webinar. And I do want to remind everyone that we have a more informal question and answer session after this presentation, and that is just for the admitted students if they want to ask the student attorneys any further questions. There is a new Zoom link for that session, and that's included in your admitted students program as well.
Thank you all so much. This is so wonderful to hear my students speaking about their experiences. So we'll have you post any questions through that Q&A function at the bottom of your screen there. So we'll give folks a minute. And if there are no questions, that's also fine. We can wrap up a little early, but feel free to use that Q&A function if you do have questions for us. So it looks like we have one question. It was great to hear Emily talk about what she found most rewarding. Perhaps a few other students could share what they found most rewarding from their RHRC work. So maybe we could end with that question. I don't know if one of you wants to, or each one of you want to go around and just give some thought to what you have found most rewarding so far. I know we're not quite done with the academic year, but what you found most rewarding so far in your work with Clinic.
I can start. So I was a French teacher before coming to law school, and it was really important to me that I get to keep using my French skills. And one of the clients that I've been working with is a French speaker. And so that's been really wonderful for me to feel like I can still use a tool that's been important to me throughout my entire life in a very different way. And I think honestly, just like the people, you will have probably heard this so many times with the community at Maine Law, and then the ability to interact with the community in Portland has just really, even during the pandemic, to just be able to feel like I have connections and I'm making an impact and I'm learning so much from my peers in my community is an amazing opportunity. And what I think it fits the box of rewarding for sure.
I'll go next. Prior to law school, I was a stay-at-home mom for 18 years to my 6 children. And so what I have found really rewarding about being a part of the RHRC clinic is that it has helped me gain confidence in my legal skills. And while my classes helped me gain legal knowledge, clinic has in addition to gaining legal knowledge, has also helped me develop tools that I will be able to use in future practices, and small things that, such as time management skills. When you're juggling all sorts of aspects of a case and multiple cases, those are really valuable skills to develop, and have a very hands-on experience under the guidance of such amazing supervisors who are very nurturing, incredibly knowledgeable, and definitely want to see us succeed.
For me, I shared a lot of my story yesterday, but I am coming from a science background where I didn't get to interact with people very often. And so my choice to go to law school is very people focused. I knew I wanted to be helping people and interacting with people and navigate legal issues. And so the most rewarding part about RHRC for me is that it's confirmed a lot of the reasons I wanted to go to law school. I like the substantive classes, I like being in class, but I don't think I came here for that. I definitely came here to use those skills, use that knowledge to help people. And I think even the hard conversations that I navigate with my clients are still just super rewarding to be there for them as they're navigating that process, and delivering the bad news, I think, is still, although it sucks and it is a hard conversation, I think that's been also rewarding in the fact that I can be that support for them. I can help explain what it all means and explain what our action plan going forward is. I think just the confirmation of why I came to law school has been super rewarding for my RHRC experience.
Terrific. I don't know if Grady or Emily, if you want to chime in, or we can move on to some of the other questions.
Just briefly, I'll echo that working with clients has been far and away the most rewarding part of the experience. I have a client with young children, and we now try to do meetings without the young children because they can be a bit distracting. But the first meeting that we had, the young children all came, and it was a crazy meeting, and it was really, really touching, I guess, to be working on behalf of these kids and their family, and knowing that the work that we do in the clinic is really, really, really important to them, and that they wouldn't necessarily have access to legal representation without the clinic's work.
I think the dry erase marker all over the wall could count for a test to the craziness of that first meeting.
We figured out how to get rid of the marker on the wall, but it took a few weeks.
Great. And I know, Emily, you've already spoken about what you found most rewarding. So let's turn to one of the other questions. We've got a question here about what percentage of RHRC graduates have gone on to practice in the immigration law field. So probably I'm best suited to answer that question. I would say the majority go on to some sort of public interest or poverty law focus as their full-time practice. But even those who go on to private practice, I would say, I mean, we have expanded ILAP, the Immigrant Legal Advocacy Project's pro bono pool of asylum attorneys dramatically. So almost all of the students who stay in Maine have joined that pro bono panel. And some semesters, you know, I think last spring or maybe a year ago, I had most students did the clinic were interested in immigration law, and I would say, I think it was 60% of them went on to actually practice full-time immigration law. So the multiplier effect, sort of that earlier point I made, is real. We're training the next generation of students, but then if you think even one student who goes on to take on, you know, asylum cases, even if it's pro bono, just think about the multiplier there of how many families and individuals are helped through the students who graduate from this program. So I think I have this, the breakdown of where all of my students land, and I'm a little bit behind, and then I think I'm about a year out and needing to update it. But I think most of them, again, if they go into private practice, they take it on pro bono, but many of them go on to make it their full-time career, whether it's immigration or poverty law or public interest focus. But certainly, as has been mentioned, it's certainly not a requirement, and we are training the next generation of attorneys, regardless of which area of law they intend to go into. So another question about what determines venue in these cases. I guess it depends on which case, but our law, U.S. Immigration law and procedures determine venue in terms of where folks end up. So for example, in an asylum case, if you are in Maine and you entered on a visa, maybe you came in on a student visa or a visitor visa, and you're afraid to go back to your home country, and you're seeking asylum, you would apply for asylum before the Boston Asylum Office. But if you're in immigration, if ICE has caught wind of you, or if you're out of status and ICE has caught wind of you, or maybe you crossed the border, I mean, this is the population Grady's working with, many folks are put, many folks are put directly into removal proceedings. And so in Maine, for example, if you have you came across the border and you were issued what's called a notice to appear, you're told to go to immigration court, you won't ever appear before the Boston Asylum Office. Your first place you would present your asylum case is the Boston Immigration Court. So it depends on sort of the procedural posture. It depends on how you came into the country. So venue, and that's just asylum. So there's, I think venue will depend on what type of immigration relief you are seeking. But I would say, for a lot of the cases in Maine, many people first go before the Boston Asylum Office, and then if you lose at that level, if your case is referred, you're referred to the Boston Immigration Court. And we, again, in the report, we articulate how, if you're referred, the impact of that referral. But many of our clients also win asylum. They gain asylum before the immigration court, demonstrating that these are legitimate claims, approvable claims, but not before all of the, incredible impacts on family and the system more generally. So hopefully that answers that question. And feel free to reach out to me if you've got more specific immigration law focused questions. I imagine this is a question, how do you actually join the RHRC? I imagine this is a question that many of our admitted students here on the panel are curious about. So my clinic is one of the only ones that has an application requirement, and that's only because I wanted to ensure that students who come to Maine Law to do this clinic, to work with asylum seekers or with immigrants more generally, actually get that opportunity. So it's a one-page short application just indicating your interest in the program. And then you can begin as early as your first semester of your second year to enrolling in the Refugee and Human Rights Clinic. The other clinics are primarily lottery based, but in mine you apply, and then every semester we take between 6 to 8 students, and it's a semester-long program. So absolutely happy to answer more questions about the process of enrolling in the RHRC, and we can definitely talk more about that in the next Zoom as well.
Can I add something really quick?
Yeah,
Anna?
please do. Yeah, absolutely.
I mentioned when I was talking that you can volunteer as early as your 1L year, and so that's a really good opportunity. I think Aisha, even though she's not doing clinic this semester, is still volunteering in the clinic. And so there's some hours where our office administrator can't be at the desk, and somebody needs to answer phones or help student attorneys with different things. And so from day one, I was in the RHRC trying to get my volunteer hours in and meeting student attorneys and getting some of that experience. So even though you can't officially be a student attorney until your second year of law school, you can get involved really early on.
That's a really good addition. And I actually encourage that early on and often. And some of our volunteers, I think Cameron and Aisha, I knew even before they came to Maine Law that first in September, their first year. And we love folks to come in and work the front desk. And I'll do a recruitment of anyone who speaks a second language or third language. And we do a whole interpreter training and translator training. So if that's of interest to you as well, we rely heavily on interpreters and translators. And of course, we work with, House of Languages and other vendors who provide professional interpreters, but I often find our volunteers who've gone through the training are equally, if not even better sometimes, than our paid interpreters. And where we're funded by donor dollars primarily, it's really helpful to have those volunteers. So if you're coming to Maine Law, get ready to hear from me with respect to various volunteer opportunities. So I think we've gone through all of the questions that were posed during today's session. So I just want to thank all of you, those who organize this, and certainly to my students who I adore, and I'm so grateful to be working with you, and just so proud of the incredible work you've done. And we will, I guess, disconnect and hope to see all of you soon. Okay, take care.